talk about the developments in the case of the missing West boys. The boys' adoptive parents, Trezell and Jacqueline West, both arrested and charged with 2 counts of second-degree murder, 2 counts of willful cruelty to a child, and reporting a false emergency. David, thanks so much for being with us this morning. We appreciate it.
My pleasure.
You've had over 30 years of experience in both federal and state criminal defense. Just how rare is this kind of indictment?
Well, normally in a federal court, I've been practicing there for over 34 years, and in the hundreds of cases that I've handled there, I've never handled a preliminary hearing because the federal court does take good use of the grand jury system. However, here in Kern County, I have had an opportunity to defend individuals who have been indicted by the grand jury. So it is rare that this actually happens, but it does happen for a reason.
Can you explain that process? Why the grand jury? Why would that be used in a case like this? And does that change anything going forward in this process?
It doesn't change anything, but for the most part, a grand jury is a secret proceeding. And the idea being is that this information is going to be provided to the grand jury. And in the event they don't find sufficient evidence to indict an individual, then that person, his or her identity is kept confidential, and they go on living their life without having subsequent implications. However, if that person is indicted, we've then jumped one step. For example, when a person in state court charges or a complaint is filed against them, that's when we begin. From the complaint, you go through a preliminary hearing. A preliminary hearing is a hearing where the court determines whether or not there is significant or enough information or evidence to refer this person's case to trial. If the judge says there's enough information, then an information is filed against the person. Here, the grand jury just skips all of that process. The grand jury says we believe that there's sufficient information to proceed to trial, and then they start at the trial process where the persons actually have up to 60 days to get to jury trial.
And there can be significant delays when it comes to a preliminary hearing. So this basically skips ahead a little bit in that process.
If this was a preliminary hearing, for the most part, the investigation would be open. A lot of folks would know about the case. And you know, if a person is in custody, based upon the amount of time it takes in order to prepare for a homicide case, that case may go to preliminary hearing anywhere between 6 months to 1 year. But in this particular case, there is no preliminary hearing. There has been a determination that there is significant, that there is enough evidence to proceed to trial on the case.
And in this case of the grand jury and the way that's done, the people who are being investigated, Jacqueline and Trezell West, would not have known that they were under investigation by the grand jury.
That is the intent. Yes, that's correct.
Okay. Can you explain the difference between second-degree murder and first-degree murder? They are facing these 2 charges of second-degree murder, also willful cruelty to a child. In which kinds of cases is second-degree murder warranted over first-degree?
Well, first of all, we have to remember that first-degree murder is premeditated murder. It's where it's willful, deliberate, and premeditated. And a lot of times when you look at a certain statute, Penal Code Section 189, it tells you what it is. For example, if a person knows, I'm going to kill Johnny and I'm going to wait in front of his house until he gets home from work, behind the bushes, Johnny comes home, he shoots him. But that has been planned. It is deliberate. It is premeditated. He knew he was going to do it. Second degree is a little bit different because although it may not be premeditated, even though it may not be premeditated in terms of the first charge, it can still be willful. If you want to go in and you want to shoot at a crowd, it's that type of reckless behavior. If there was a situation where these children perhaps were either beaten on an ongoing basis, or something happened where because of the action of the defendants, these children suffered as a result at the hands of their parents, then more likely than not, that could be second degree as well. The thing with child abuse, those cases are very difficult because if you do prove that particular charge, a person can serve up to life in state prison on that.
Okay, so that does change what they are facing in this case.
It does. It does change it significantly. I've had many of those cases, and the thing is, quite frankly, whenever a defense attorney is defending a case where a person is charged with harming a child, you know, there are those allegations. Once evidence begins in jury trial, it pretty much becomes a very difficult case to try.
Yeah, it's going to be very difficult for our entire community, I'm sure.
It is.
David Torres, thank you.